Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Welcome back for another Legal Tea episode today, 122 episodes in. And happy December, by the way. Where has this year gone? And you know what? As I'm sitting here saying that, I feel like we all say that every year, which is probably a reminder that we need to enjoy the little moments because time flies. Anyway, today's topic is a current trend, and on this type of episode, we dive into something in the current time or that I've stumbled across that is pertinent to my little estate and elder law world. And for today's episode, as I shared a little hint at the end of last week's episode, it is inspired by one of my teammates who, in his free time, enjoys playing video games. And a few weeks ago, he was telling me about a game that he was playing called Starfield, and how in it, there's a level that is called Last Will and Testament Quest. So according to Gamer.com, the level basically centers around you, the game player, finding someone's will, because in the game, you learn that the person that passed away left a house, among other assets, and they do not have any known heirs or known family. So this whole quest is about finding their will to see who the beneficiaries are and who should really own the house that was left. Well, a little insider secret, according to Gamer.com, is there is a will, and that's what the quest is about. First, seeing if they left a will, and second, finding the will. So my team member is telling me about this level, and he said, Jenny, you should totally do an episode on your podcast about what happens if an estate plan is lost or cannot be found. So that's exactly what we're going to do, my friends. And it's inspired by this Starfield game's Last Will and Testament Quest. It's also why I'm totally counting it as a current trends episode, just because it's, I guess, maybe a current new game. But anyway, let's talk about what happens if an estate plan is lost or cannot be found. So first and foremost, I think we should talk about whether estate plans get recorded or filed anywhere while you're living. Now, I'm sure some states do allow for it. I kind of put some feelers out, and a lot of states don't require it, but do permit it. Some states just don't even permit it. I'm based in Indiana, and we do not have to record or file estate plans with the state or county or court or anything like that. And if you're a longtime Legal Tea listener, I did a cautionary tale episode a while ago about a real life client that had passed away and their family could not find their the loved one's estate plan at all. And I'm actually going to talk about it a little bit during this episode. But long story short, I had to get the court involved, and it was a whole thing. So trust me, people, this, quest, as Starfield calls it, actually happens in real life too. So like I said, here in Indiana, we do not record or file documents anywhere. We don't have to record or file documents anywhere while people are living. If I went to the courthouse with my client's estate plans, the courthouse staff would be like, "Go home, Jenny. We don't do that here." But in other states, like I said, other states allow it, but they don't require them to be filed or recorded. So all that to be said, just check with an attorney in your home state. Now, something else on this topic is kind of what we talked about in our last Legal Tea episode, which is a cautionary tale type of episode, where a woman held property with her deceased mother. Well, her mother died in 2011, and because she did not probate her mother's will within 3 years of her mother's passing, which is a kind of an Indiana-specific thing, her will became essentially a moot point, and now things are totally going sideways. So I encourage you to listen to that episode because when someone passes away, it is vital to find an estate attorney and confirm whether anything needs to be done. Had the attorney done that, or had the woman done that, the attorney would have immediately been like, "Okay, does your mother have a will? And if so, let's find it." And I say this because sometimes families, after someone passes away, they do not know where their deceased loved one kept their estate plan. Is it a bank safe deposit? Is that a bank in a safe deposit box? Is it in a safe, like a fireproof safe in your home? Is it in the freezer? I kind of jokingly say that because my grandma used to put like really important stuff in the freezer. Like, where is it? In those cases, those families are embarking on a real life, Starfield life, last will and testament quest, right? So let's talk about that real life story that I referenced and what happened there. And what you, my friends, can do to avoid this happening to your family. Alrighty, here we go. So one day, a paralegal, she grabbed me because she had just taken a kind of a weird call and wanted to make sure that we could even help this prospect. And I was like, okay, lay it on me. What's going on? She proceeds to tell me that the person on the phone shared that their family member passed away, had an estate plan, specifically a trust, and that assets are held inside the name of the trust. But no one can find the trust document. They've searched high and low, and it's nowhere to be found. Before I really developed like a plan of attack, I needed to gather more information from the prospective client so I could make their upcoming meeting with me like super productive. And mainly, mainly I needed to know who was involved, like family member wise, as well as asking for someone to send me some documentation showing what assets were inside the name of this missing trust. After I gathered, family information and some financial information, the caller, the lady that had called had, sent me a whole bunch of other stuff, and I started to connect the dots. So let's see if you can hang with me on this one. Sorry, I had to take a quick drink. So the trust was actually the caller's grandmother's trust. Now, the grandmother had passed away like 10 years ago. And the grandmother had one child who was the caller's dad. So the caller's dad passed away just a couple years ago in 2021. And the caller was administering her father's estate when she located the assets that were held in her grandmother's trust. So let's do it like this, maybe if you're more of like a visual person. So think of grandma like at the top tier. She passed away in the early 2000s. Grandma had one child who passed away in 2021, and imagine him as the second tier. The third tier represents the grandmother's child's children, so her grandchildren, right? And that's the caller and her 3 siblings. Excuse me. Sorry, I just have something going on. Anyways, so I'm not over here like nothing's peppery. I don't know what's going on. Anyways, so where was I? So I had conducted some sort of research and I was ready for the meeting with the prospect. And I remember telling my coworker who was joining me for the meeting that I really hoped that the prospect was like a reasonable person because there's a legal process that we would have to go through. And it wasn't going to be easy and it wasn't going to be fun, but it was the appropriate course of action. You see, the financial institution that was holding the assets inside Grandma's trust stated that they needed something showing that the granddaughter, the caller, the person calling my office, was now the trustee of Grandma's trust. Well, to me, the issue with that sentence is that it totally minimizes the appropriate process. I think the caller thought I could just whip up a document that states, okay, now this person is the successor trustee. If I did that, I'd be taking on probably some sort of liability myself. Like, what if Grandma's Trust actually put a bank as a corporate trustee, and that bank should have earned compensation serving in that role or something? The dang document was lost. It was missing. So I explained to the granddaughter I can't just willy-nilly appoint someone as the trustee. I mean, I'm just not that cool and powerful. Attorneys have a lot of power in the legal system, but not that much power. So at this point, I shared this with her, I firmly believe that the only person, said in air quotes, that has the authority to appoint a successor trustee without a trust document would be the court. The court's the person, and have the judge appoint the successor trustee. Was it going to be annoying and cumbersome? Yeah, but that was the honest to goodness best solution for this family. So I proposed to the granddaughter that we do two things. They said that we should get a probate estate opened for grandma, and once the probate estate is opened for grandma, we can ask the court to make the trust assets payable to grandma's estate. And after all my research, there may have been ways to do all of this an easier way. But what I was most concerned about was the liability also for this family, the granddaughter especially. Like, what if the trust gets found 20 years later somehow, some way, and the trust beneficiary was like a church or a charity or someone else besides the family? I told the granddaughter that there was probably some ways that we could have done it cheaper and maybe, easier, by throwing together some sort of agreement between all the parties, like all the grandkids, kept the court out of the picture, all the stuff. But if it were my family, this is the path I would recommend of involving the court and having the judge appoint the next trustee. As much as I don't like getting the court involved, were also a couple advantages in doing so as well. First, part of the probate process is to, publish notice of the estate, like to the world, like in a newspaper. What does that mean? So going through a more formal process would start tolling the statute of limitations on anyone trying to kick up a fuss later. As in, say my example earlier, what if grandma did put her church as her trust beneficiary and they happen to find a copy of her trust? Ideally, the statute of limitations is told and they would be essentially kind of SOL, crap out of luck. Not crap, but you know what I mean. Second, running it through the court will also just make things cleaner between grandma's estate, paying her son's estate, and then the son's estate paying the son's 4 children, so the grandma's grandchildren. So because the court is involved, and me, the attorney, is involved, things will just be kept on the up and up more to, again, just make sure everything is clean and everyone's on the same page. And not to mention, we will have court orders to provide to the financial institutions to force them to comply. So again, this whole cleanliness thing in mind. So that's what we did. The client listened to my recommendation, and they didn't have to, but she did. And I remember her saying, "Jenny, I hear you. That's the route I'm going to take." And she could have very well said, "But I think we're just going to do it the cheap and easy way and hope for the best." They didn't, but if they chose that, I would have instantly started papering the heck out of my file. I recommended this family to do Y, and they chose to do Z. That way, if anything did happen in the future, they could not come back to me, basically point the finger at me. But thankfully, she recognized that the involvement of the court was actually a good thing. It formalized things and ultimately gave the family peace of mind, knowing finally, after many years since grandma passed away, that all T's were crossed and I's were dotted. So, my friends, when it's time for you to hashtag do your estate plan, let's be sure it doesn't get lost. There are a few things that you can do after your estate plan is created to ensure your family is not in a similar boat. First, you can put your documents in a safe place, but also put them in a place that is sort of intuitive for your family, especially if you choose not to tell your family where you have put your documents. Oftentimes, I recommend a fireproof safe. This investment is something it just is so worth it. Along those same lines, I'm not a big fan of putting documents, estate planning documents, in a bank safety deposit box. Banks get really weird when people die and oftentimes do not let the family get into the safety deposit box. Second, perhaps you can make digital versions of your documents and store them safely on your computer. And by the way, if this route is a thing for you, do make sure your family knows how to get on and log into your computer if you were to pass. That's kind of an important side note. Third, giving copies of your documents to your kind of first person in charge is both a good and maybe not good thing. It just kind of depends on your desire. It's a good thing because they would, of course, have a copy of your documents if something were to happen to your originals. But it's may not be so good if you were to update your documents at any point. You would have to remember who has copies and to get them replaced. It's especially not good if you're yanking out that person. So the last thing you want is to give someone a copy, you update them, and not give them an updated version, right? And then they inadvertently operate by outdated versions. So just kind of tread carefully with giving people copies of these sort of documents. So hopefully those are some good tips so that you don't end up with a lost or missing estate plan. And this is a good episode, huh? So, many thanks to my team member and his, video game for inspiring this episode and really advocating for this conversation, honestly. I'm out of time, so let's wrap this episode up. Next week, we're back to the celebrity estate planning type of episode. And during that episode, we're going to dive into what happened estate-wise following the passing of old David Bowie. So definitely tune in next week for an episode on his estate. It'll be a good one. Talk to you then, and stay well.